All right, we have one other case this morning. And as council is set up, we will call 24-1330, Courtney Cortez Chestnut versus the Iowa Department of Public Safety. Michels will be arguing for Chestnut, and Mr. Brakhahn will be arguing for the Iowa Department of Public Safety. So, whenever you folks are ready, we're ready for you.
May it please the court. My name is Chad Brakhahn. I represent the Iowa Department of Public Safety in this matter. To start out with today, I want to acknowledge that the appellants here asked the Supreme Court to retain this case in order to reconsider its decision in the in the interest of TH decision from 2017. But this court today doesn't need to overrule TH in order to reverse the decision of the district court. There's a couple of key issues with the decision of the district court.
Start with the timeline, because I'm having some confusion, mainly because I'm not sure this is in the record. But just from a timeline standpoint, I'll tell you my understanding, you tell me if I'm wrong. So Mr. Chestnut commits the delinquent act as a juvenile in 1994. In 1995, the legislature enables or creates a statute that requires sex offender registration, right? And then Mr. Chestnut's adjudicated, and so he's subject to the registration requirements. He's in custody till 01, so his 10-year meter doesn't start until then, right? So it'd be through 2011. In 05, they amend the statute to add provisions that if convicted of a registry violation, it adds 10 years to your registration time. And then in 09, they kind of revamp the whole thing and put on more onerous restrictions and lifetime bans and all that type of stuff. Is that accurate so far?
That's my understanding of the timeline, Your Honor.
Where I'm confused is how many violation convictions does Mr. Chestnut have, and what are the dates of those? And if those are in the record, can you tell me where, because we can't find them?
I would agree, Your Honor, that I think it's less than clear in the record, and I believe the court could take judicial note of these following cases. We have a AGCR 217928, which was Polk County in 2000. 928, Polk County, and that's January 1 of 2008. We have FECR 236497. That's Polk County, April 7th, 2010. And then we have FE
36497.
36497. Thank you. And we have FECR 258257. It's also Polk County, July 7th, 2012.
The first one, the AG was a 2000 conviction?
2008.
Okay. All three are Polk County? Okay.
And I guess I want to clarify my answer to your question, Your Honor. The answer I gave you is for the sex offender registration violations. Those were those three.
Crimes for violating the registration requirements. Okay. So what are the relevant?
I guess I should say that I provided with the date of charge, not conviction, I believe. I'd have to clarify on that.
And so are the relevant amendments here the 05 amendments or the 09 amendments?
I think for purposes of the legal issues before the court, what we're looking at is the 09 amendments.
Because all of his convictions for violating occurred after, well, Some became before '09, some came after.
That's right. That's right. Okay. So there's two large issues that I think that the district court made that affected the ex post facto analysis. And the first is their reliance or their interpretation, application of in re TH. In re TH is not, it does not directly control the facts of this case. If you read in re TH, the Supreme Court looks at the 7 Mendoza-Martinez factors to determine whether or not the 2009 amendments as applied to a juvenile are punitive. And the court finds that 4 of those factors favor punishment. 3 of them do not. One of the 4 that favors punishment is slightly in favor, but there's 3 others that the court relies upon to find punishment. And in the court's reasoning, it is on 3 of those 4 factors, the status of TH as a juvenile at that time is of fundamental importance. And if you look at the court's decision in TH on page 588, the Supreme Court is looking at the effect of a 300-foot restriction from any place that minors attend. And the Supreme Court reasons this restriction could prevent juveniles from participating in pro-social after-school activities, sports teams, youth clubs that are available to peers, which in turn severely limits their opportunities to develop communications and social skills with children their own age. Whether or not it's been historically regarded as punishment, on page 592 of TH, the Supreme Court is looking at the disclosure, the lack of confidentiality that attaches to these types of situations, and the privacy that is generally afforded to.
Use TH in a way that is kind of extending the balancing that was done in TH to say, hey, this kid was 11 or 12 when this happened. Given our history of juvenile offenders and that they're oftentimes, not going to be people that re-offend, that the sheer number of restrictions imposed on juveniles given the demonstrated low juvenile recidivism rate is excessive in light of the civil purpose of preventing multiple offenses. So you're saying that TH doesn't apply to this case?
I'm saying what the district court did is largely adopt the analysis of TH, and that analysis was permeated by the fact that TH at that time was 17 years old, and many of these considerations that rendered the 2009 statute punitive for TH as a 17-year-old do not apply to an adult such as the appellee in this case. In fact, the court in TH noted that, in the totality of the statutes and positions coupled with mass publication of juveniles information, we find mandatory registration for juveniles is excessive. And the Supreme Court has since, TH, has entered an opinion in State v. Aschenbrenner, which finds that this statutory scheme is not punitive for adults. In Hess, the Supreme Court clarified even further that this statutory scheme is not punitive even for a juvenile who's prosecuted as an adult. And what the district court did here was instead analogize facts which aren't necessarily analogous to TH and really expanded the TH exception to the enforcement of this code.
I'm trying to summarize in my head, kind of your argument is, okay, so he commits the Delinquent Act 94, 95 gets adjudicated, the SOR law is on the books. We've got Supreme Court cases that say, before TH and the 2009 amendments, that say this is not punitive, so there's no ex post facto issue. So he was required to register. The registration period began in '01. at which point he's an adult. And so now he has the registration requirements. As an adult, he commits the crime of violating the SOR requirement. And that results in, the consequence of that adult criminal act is that, because of the 05 amendments, tacks on 10 years to his registration period each conviction. Is that a fair summary?
And Your Honor, under Aschenbrenner, we would know that application of the 2009 registration requirements to an adult, which the appellee was an adult in 2009 or 2011, if that's the point you look at when he, at whatever period in time around there that we look at, or 2008 at the time of the first violation, or 10 or 13. But the case law is consistent that application of these requirements onto an adult is not punitive. I see that I'm running out of time, but we'd ask with a close look at the reasoning of the court in In Re TH, its subsequent decision in Aschenbrenner and Hess. What we see from the district court is really an expansion of TH that is not warranted by the Supreme Court's case law. Thank you, Your Honors.
5 minutes on rebuttal. Mr. Michels, whenever you're ready.
May it please the court, counsel. Scott Michels on behalf of Courtney Chestnut. The law is clear that enhancing a previously imposed punishment through a statute that was later enacted violates the prohibition against ex post facto laws. Had the legislature made registry violations a separate registrable offense, we're not here today arguing whether or not an additional 10-year registry requirement violates ex post facto. The legislature is free to alter the punishment for registry violations, but it cannot accomplish that goal by means of a post hoc alteration of the punishment for an earlier offense.
Do you agree that the extensions all stemmed from convictions for acts that took place when that law was on the books?
Yes. I mean, the law went on the book, and, well, if we really want to go back and look at it, when the law was enacted in 1995, there are punishments for violating the registry requirements.
A 10-year tack on.
The 10-year tack on.
In 05, they changed the statute to say there is a 10-year tack on.
Yes. Now, what?
Books in 05, and Mr. Chestnut commits each of his criminal violations for which he was convicted for conduct that occurred after the effective date of those 05 amendments.
I agree with the timeline, yes. Now, here's my position on it. The statute, if we look at the plain language of that statute, 692A 106 sub 4, as it relates to Mr. Chestnut, states, a sex offender who is convicted of violating any of the requirements of this chapter shall register for an additional 10 years, commencing from the date that the offender his registration would have expired under subsection 1. So it's an addition. We're extending that original registration, because if we go back and look at the way the statute was enacted originally, everything in 1995, if it was a registrable offense, was a 10-year requirement. It wasn't until July 1st of 99 that that the legislature added in the aggravated offenses, which then those are automatic lifetime, which Mr. Chestnut's offense would be, because it's sex abuse second, because he's 12, at 11, 12 at the time he commits the offense. And typically, you're going to perpetrate against somebody who's your age or younger. So he automatically if we would have applied, or if that would have been applicable at the time, he's automatic life. But what ended up happening when they revamped the registration, or the registration code in 2009, they threw in that catch-all, or that provision, the retroactive application. So at the time that Mr. Chestnut was required to register, it was 10-year. 2009, retroactive application of that chapter goes into effect. He's now lifetime registrant for an offense he committed when he was 11 or 12.
This isn't requiring lifetime, isn't saying it's lifetime, right? They initially did, but they backed off that. Once you challenged it within ATH, they said, no, okay, it's through 2046. Okay.
Backed off, said, but it should also be noted, if we look at the language from the determination decision, it says, and I quote, "Your registration period has been extended until November 10th, 2046, end quote. It's an extension of that original 10-year registry. Now, if the legislature would have made registry violations a independently registrable offense, we're not dealing with ex post facto, because now that actually falls into the habitual offender statute of the registry, which is the next subsection, subsection 5, which states basically any person who is convicted of a second or subsequent registrable violation is required to register for life. That's where you get a habitual offender, not this other not the subsection 4, where it just adds time on. That is more in line with the cases, the federal cases that I cited in regards to 18 USC 3583 sub G, where an offender commits an offense, they get put on supervised release, they then enact a different statute relating to supervised release revocations, which then required, I think it was a mandatory minimum imprisonment if you were violated under that code section. And the Meeks, Pascal, Perrier cases all dealt with that, where the offender is on supervised release, the law changes, they committed a supervised release violation, it goes back on the violation, they get punished under the new section. So it altered the original punishment that was there at the time they committed the offense. And it ended up enhancing the punishment that they would have otherwise received at the time that they actually committed the offense. That's what we have going on here. At the time Mr. Chestnut committed his original violation that landed him on required the registration, it was 10 years. That was it. There's nothing related to additional time for registry violations until 4 years after he's even required to actually register. So it's...
First of all, do you agree that the dates of his convictions for violation of the sex offender registry is not in the record?
I agree with that.
Do you agree with the dates that opposing counsel gave for those?
I wouldn't disagree, or I guess I wouldn't, without looking at it, I wouldn't. This sounds approximate, yes.
Objection to us taking judicial notice of those 3 files that he gave us?
No.
Okay, and it is 3 files?
As far as I'm aware, yes.
He was required, do you agree that he was required to register from 2001 to 2011?
Yes.
Original delinquency adjudication?
Yes. Because
Okay.
that law, at the time, the registry was not a punishment. We were using the U.S. Supreme Court case, which, funny enough, that ends up going back to Alaska Supreme Court, and they overturned that and found it to be a punishment and violate ex post facto under their own state constitution.
All right, I'm having trouble understanding why this isn't a consequence of an adult criminal act, as opposed to an extension or excuse me, an increase of the punishment of the original offense. Is that partly based on the fact that all 3 of his convictions occurred during the 10-year registration period? Nothing to do with it.
It has nothing to do with it. My argument. Oh.
Challenge any of the 3 convictions on ex post facto grounds, to your knowledge?
No. No. I'll be honest with you, Judge, I haven't really looked into what the underlying facts of the violations were. I believe one of them was for violating the 2,000-foot rule, which obviously was not in effect in 1995 or 2001 when he was placed on the registry. But that's the thing, like when you talked earlier about the department has got rid of the lifetime registry because of NRATH, they were still picking and choosing which later amendments to apply to Mr. Chestnut, because if you look in the record, there's an exhibit that his website submission, or, you know, what was showing up on the website. Website didn't go into effect until 2009, yet they were applying that to him, placing him on the website. And additionally, the residency requirements, exclusion zones, all of that stuff that were instituted after he committed his offense and after he was placed on the registry were being instituted on Mr. Chestnut.
Understanding how this is different than, and I know your firm does a lot of OWI, so and you do too, I believe, so you're familiar with this, but I'm having trouble how this distinguishes from back when the OWI had a 6-year look back, right? And so somebody commits an OWI, they get through the 6-year look back, say they're 7 years out and the legislature passes a law that says now it's a 12-year look back, and in year 8, they committed another OWI. Our Supreme Court has said, yeah, that law was on the books when you committed it. It's a 12-year look back when you committed it, so it is a second offense, right? How is this different than that?
Here's how it's different. If we look at those Meeks, Perriott, Pascal cases, you're punishing the past conduct. In the OWI statutes, where the habitual offenders, you're punishing the future conduct. So in your instance, year 7, they do the 12-year look-back window. You're on notice that if I commit another one in the next 5 years, I'm getting a third offense, right? At the time that Mr. Chestnut committed if we look at it, at the time he committed his offense, the registry wasn't even a thing. My argument is that violates ex post facto in and of itself, but
How is that not the same thing, though, that he's on notice as of 2005 that if he commits a registry violation, he's going to get a 10-year tack on, and he commits the crime anyway? Why isn't that the same thing?
over time,
Yeah, please go ahead.
in that instance, or in this case, right, yes, he would have had knowledge, but if we look at those federal cases, they say it's just as true that Mr. Chestnut did not have the foresight of knowing that a registry violation was going to land him on the registry longer at the time he committed his original offense. But that's ultimately what we're doing here is, so for instance, if instead the legislature had said, let's say the legislature says, we're going to institute a 10-year registry for a violation, right? But it's not in addition to, it's just a separate one. Now you're not adding on. So this is an easy fix for the legislature. You either institute a straight 10-year registry or whatever number they want to put, but not in addition, so that you're not extending that original punishment. Because this doesn't apply to adults or to juveniles in adult court. It only applies to this limited group of people who were adjudicated, and in this case, adjudicated for an offense that occurred prior to 2005.
Thank you.
Thank you.
And if you need a little extra time, we're glad to give you a little.
Real quickly, the language indicating the additional 10 years is instructive on how to count the period of time. If somebody's already under a certain period of registration requirement, the phrase additional 10 years just informs when we start counting that new 10 years. It's not indicative that in any way this is punishment.
To some degree, right? Because you have to be on the registry before you can be convicted of violating the registration requirements in the first place, right?
As currently drafted, you have to be on the registry to be found in violation of that. And, the Hess decision, once again, indicates that the sexual offender registry requirements are not part of the original sentence. They're an automatic collateral piece. And this kind of, I think points to the second, or leads to the second issue that I wanted to discuss with you that I see with the district court's decision. And in determining whether or not this operated, not in the punitive sense, I think the TH analysis looks at whether or not we're punitive or not, but looking at whether or not this operates, retroactively. The district court put a lot of reliance on the State v. Lathrop case. And the State v. Lathrop case dealt with a statute which imposed lifetime parole on certain individuals convicted of certain sex offenses. And so this was a case where folks had already been tried, already been convicted, and already been sentenced for a sex offense, and to retroactively apply this special sentence to that individual effectively would impose lifetime sentence, but with parole. The district court found that to be analogous to requiring somebody to register for 10 additional years if they failed to meet the registration requirements. There are fundamental differences between imposing effectively a lifetime sentence on an individual without any further conduct by that individual, compared with this situation where if somebody subsequently failed to comply with the registration requirements, then they would have an additional period of time, or a defined period of time, 10 years, added to that registration requirement. The district court's reliance on Lathrop, we think, was improper, and the court should find guidance more. I think, Your Honor was suggesting the DUI scenario and the State v. Stone case from 1999. On that point, we find much more analogous to this situation. And with that, thank you, Your Honors, for your time. We ask that you reverse the district court's decision.
Excellent arguments today and briefing. It was very helpful, and we will consider 24-1330 Chestnut versus Iowa Department of Public Safety submitted, and my colleagues and I will get a decision out as soon as we can. Thank you so much today.